Hello everyone, and welcome to Uncivil Law. For today's case, we have United States of America versus Bryan Moran. In this case, Mr. Moran was storing drugs in his sister's storage locker. The police came to information that suggested that there might be drugs involved and conducted a search. The question for the Court of Appeals here is whether the search was proper. That is, whether or not the police had the right to conduct the search they did, and whether or not the evidence that was discovered should be suppressed or not. So let's get started with this. Bryan Moran pleaded guilty on May the 9th, 2018 to possession with intent to distribute fentanyl. He reserves the right to challenge, on appeal, the denial of his motion for reconsideration of the denial of his motion to suppress certain evidence, specifically fentanyl obtained from within closed black garage bags that were found within his sister's storage unit during a warrantless search. The district court based its ruling on the ground that a person with apparent authority to consent to the search, namely Moran's sister, gave it, even if she did not have actual authority to do so. Because we agree with Moran that the government failed to meet its burden to show that his sister had either actual or apparent authority to consent to the search, we reverse the denial of the motion for reconsideration, vacate his conviction, and remand the case. So here the police were not conducting a search pursuant to a search warrant. They were conducting a search pursuant to consent. But the consent was not from Moran. It was from Moran's sister. And although Moran's sister owned the storage locker, she did not own the stuff that was in the storage locker that was being searched. So the government is looking to admit this evidence at trial, and the Court of Appeals is saying they didn't have the right because they didn't have consent from the right person. Moran stored several closed, opaque, black plastic garbage bags that contained some of his effects in a storage unit that belonged to his sister, Alysha. A week later, after Moran was arrested, he learned that Alysha's storage unit needed to be empty. He asked her, on a recorded phone call, to move his bags. A detective from the police department from the town of Wilmington, Massachusetts, was informed of the call. Alysha signed a consent for search from that law enforcement personnel conducting the search had provided to her. This form authorized law enforcement authorities to conduct a search of her premises and vehicle, specifically of her apartment, her car, and her storage unit, and to take possession of any items found which are relevant to the police investigation. Law enforcement authorities then searched Alysha's car and her storage unit. The district court found that when authorities that conducted the search of Alysha's storage unit opened it, Alysha differentiated the contents of the unit, stating the black bags belonged to Moran, while the boxes containing Christmas decorations belonged to her. Before law enforcement authorities searched the contents of the storage unit, Alysha left the premises to pick up her child. The law enforcement authorities who conducted the search removed the closed garbage bags that are at issue from the storage unit. A police canine was brought to the scene to check for drugs and did not learn when it sniffed the bags. The canine was not trained to detect fentanyl. So a drug dog, that did not alert, even though the police were suspicious. So that's an interesting turn there. The authorities proceeded to open the bags and search for their contents and found fentanyl inside of them. Moran was indicted for possession with intent to distribute fentanyl in violation of U.S. Code. He filed a motion to suppress the fentanyl as fruit of an illegal search. The district court denied the motion to suppress on the ground that, although Moran had a reasonable expectation of privacy in the bags, the law enforcement authorities did not need a warrant to search them because Alysha had actual authority to consent for their search and voluntarily had given such consent. So the first issue from the government is that Alysha had actual authority to consent, that it was in her storage locker, and as a result, she had authority to allow for the searching of the bags, even though they weren't her bags. Let's see what the court has to say. A third party may consent to search another's effects if the third party possesses common authority over the effects sought to be inspected. Common authority rests on mutual use of the property by persons generally having joint access or control for most purposes. Such mutual use makes it reasonable to recognize that the third party has the right to permit the inspection in her own right, and that the other party has assumed the risk that the third party will grant permission. So basically saying here, if you have a joint ownership right or a joint possession right, then the other person has just as much consent to give as you do. So if you're going to store your drugs, don't store them as part of a joint ownership. Bad idea. Lynn asks, when you click the bell, is it an engagement ring? Maybe, Lynn. Very good. Thus, we have recently explained, to establish the third party has actual authority to consent to the search of the effects that belong to another, the government must show the third party had mutual use of those effects. Here are the contents of the bags, such that there is a shared privacy interest in them. Well, under the facts of this situation, is there such a shared privacy interest? Let's see what the court has to say. There is no evidence that, when Moran left his bags at Alysha's, he told her that she could open the bags and gain access to what was inside. And there's no evidence that one could see through the bags to the contents. In addition, the fact that Alysha had access to the bags at issue by virtue of their presence in her storage unit does not, on its own, establish her mutual use of whatever they contained. And the court here cites United States v. James, noting that one does not cede dominion over an item to another just by putting another in possession. So while possession in some sense may be 9/10 of the law, this may be the other 10th of the equation. While the record does show that Moran had authorized Alysha to move the bags at issue without giving her explicit direction as to what she should do with them, that fact also fails to establish that she had mutual use of the contents of the closed containers, notwithstanding that they were in her storage unit. So could the police seize the bags and then get a warrant later to search them? Presumably no, because the search and seizure would both fall under the Fourth Amendment and would have to be based on a bare minimum on some sort of reasonably articulable suspicion, which does not seem to be present here. They're just bags, and all they know is that they want them to be moved. They don't know what's inside them, so I would argue there's not enough to seize them under these circumstances, nor is there enough to get a warrant under these circumstances. That the government cannot meet its burden to show that Alysha had actual authority to consent to the search of the closed black garbage bags found in the storage unit does not, however, end the matter. The government also asks us to affirm the district court on the ground that Alysha had apparent authority to consent to the search of the items. We now turn to that issue. So, in lack of actual authority, the next argument from the government is apparent authority. Actual authority would be she really did have permission. Apparent authority would be it perceived to the police that she did. So, if she seemed to be able to do it, even if she didn't actually do, that may be enough. So, if not actual authority, is there reasonable appearance of authority? Let's read on. To resolve the apparent authority issue, we must determine whether the facts available to officers at the moment of the search warrant an officer of reasonable caution in the belief that the consenting party had authority to consent, regardless of whether the consenting party actually did have such authority. Civil asset forfeiture, maybe. I mean, civil asset forfeiture is its own little world, I guess. But yeah, you'd still have to presumably know what's inside, I would think, but eh. We consider the facts available to law enforcement personnel at the time of the search to determine whether law enforcement had a mistaken but objectively reasonable belief that the party in fact had the requisite authority to consent to the search. Once again, the government bears the relevant burden of proof. We find law enforcement authorities' belief that Alysha had authority to consent was not objectively reasonable. So the court is saying, under the total consideration of all the facts that are available, what was known to the police did not presume to give them even implied or assumed consent. In arguing otherwise, the government relies again on phone calls from November of 2015. But just as the evidence of those calls did not establish a pattern of behavior between Alysha and Moran that could suffice to show that she had actual authority to consent to the search of whatever was inside the bags at issue, the evidence of the calls also fails to provide a supportable basis on which law enforcement authorities could reasonably believe that Alysha had such authority. For the foregoing reasons, we reverse the denial of the motion for reconsideration, vacate the conviction, and remand the case to the district court. So that is the end of the case of United States of America versus Bryan Moran. In this case, we learned that the government wanted to search Bryan Moran's stuff because they believed that he might have drugs. They overheard a phone call with his sister in which he asked his sister to move certain items from their joint storage locker before the storage locker had to be removed. However, he did not indicate what were in them. And so the police relied on the sister's consent to search the bags, but the taped phone call revealed that the bags were in fact his. There was no joint sharing of authority, and as a result, the motion to suppress must be granted because the search was improper. So unless the police can show some sort of independent line of authority that would allow them to search the bags under some other set of circumstances, then his conviction will not be able to be maintained, and it goes back to district court for further findings. But for the moment, he is a free man, and that is the end of this case.